We're here today to talk about the movement of people. I describe them as the lifeblood of our business because they are probably the most important resource that you have in your business today. So first of all, we're going to have a quick look at why we were in the EU in the first place. How do things currently stand? What does the EU settlement scheme mean? What is it for and what does it do? Working in the EU for UK citizens, a quick look at the EU recruitment landscape, and finally we'll finish off with a view of the current new immigration system. So why were we in the EU in the first place? It was really straightforward that we wanted to reduce red tape, create common standards and practices across the whole trading area, and allow the free movement of people. It also reduced currency restrictions. We had no customs or duties to pay, and the VAT was managed in local territories. So how do things currently stand? In the process that we've just been going through the last 4 years, getting towards Brexit, we headed towards 31st December, and that was the end of the planned transition period. So from the 1st of January 2021, the new UK immigration system has taken effect. And we will talk about what that means for recruiting from Europe a bit later. And from the 30th of June 2021, everybody who is a non-UK citizen, an EU citizen, needs to have applied for UK settled status. And if they haven't done so, then they will not have the right to continue to work in the UK. EU nationals already living in the UK need to apply for settled or pre-settled status by the 30th of June 2021. Europeans are able to enter and make applications, stay through the new immigration regime or leave the UK after the 1st of January 2021. But they must comply with the rules of the new immigration process. UK nationals already in Europe, again, must confirm their status. And it's very similar to the settled and pre-settled status we're operating in the UK. Some European countries may have slight different variants on those rules, but if you're a UK national living and working in Europe, then you must make sure that you comply with the local regulations and make sure you get your status confirmed. UK nationals are able to enter the Schengen area for tourism and business trips without a visa, subject to time constraints, and it's 90 days in every 180-day period. Now, what's important to remember there is that that also includes your holiday, leisure, travel time as well. You've got to watch your days adding up, especially if you always have an EU-based holiday. And UK nationals working in the Schengen areas after Brexit will probably need a work permit, but it depends on the local territory, how much time you can work without a permit, and what that permit might require you to do. So again, you need to comply and understand what is required in the local territory that you're in. So what is the EU settlement scheme? And we seem to have been talking about this for a long time now. There are still people who haven't got this sorted out and applied for their settled status. The settled status scheme, it's the responsibility of the individual to make an application. It's not down to you as an employer to do that for them. And in fact, you have a duty not to discriminate against EU citizens. There will be no change to the rights and status of EU citizens living in the UK until 30th of June 2021. You will not be required to undertake retrospective checks as an employer, and there is no legal obligation for you to communicate with your staff to make sure that they've got their settled status resolved. Definitely, you should not interpret information provided by the government. And we have seen some businesses trying to be helpful, setting up workshops for their staff and things like this. You just must not do it because you cannot be seen to interpret the information. We have Tracy Munro of Mad HR on today. Just wanted to ask your opinion, Tracy, on how do businesses go about avoiding discriminating against EU citizens, but still wanting to make sure that their staff are fully compliant?
I think the best thing for employers to do is to provide as much information as they can to staff about what the settled status is and how they go about applying. And there is I believe we're going to cover it shortly, there's a very helpful information toolkit that's available on the government website with posters and things that employers can use to make their staff aware. But the important thing is that they're not seen to be in any way cajoling or harassing the staff into making sure that they've applied, and that they don't keep checking up on them to make sure that they've applied, because that potentially would be seen as discriminatory. So it's about making them aware of what they need to do, and then essentially just leaving them to get on with that. As you say there is no requirement to undertake retrospective checks even for the employer to make sure that that's being done. However, employers are still required to make sure that everybody that's working for them is doing so in accordance with the the Asylum and Immigration Act. So they do need to make sure that they've covered all of the right to work requirements for anyone that they're recruiting. As long as they do any checks company wide, so if a company decides to make a further check further down the line, which want to make sure we've got up-to-date passport copies or whatever that validation was, as long as they do it across the company and they don't single out anybody that's not from the UK, then that wouldn't be discriminatory.
Tracy mentioned there the right to work checks. So if you haven't already got a good policy in place for employing new staff and carrying out the right to work checks efficiently, then you should look at this as a policy strategy going forward. Every employer has a duty to check that a job applicant has the right to work in the UK before employing them. Check all the original documents, and you can do that online as well, but you need to have a strategy that picks all of that up. But you can be charged penalties, including £20,000 civil fine per illegal worker for failing to check. And there are more serious penalties if you were aware of or had good reason to believe that the applicant did not have the right to work in the UK. Now, one question that does arise fairly commonly is, we use contractors who tend to be potentially foreign EU citizens. What is the responsibility for me to make sure that they have the right to work? I'll ask Tracy to comment on that in a moment. Just I would always recommend to businesses to make sure that any agreement or contract that you have with your contractor places the responsibility on them to ensure that they have the right to work in the UK, and any workers that they provide also have the right to work in the UK. Is that sufficient, Tracy, or is there something else employers should do?
Absolutely. Your subcontractors agreement, so where you enter into an agreement for the individual or company to provide services to you, should state that anyone undertaking work on behalf of the subcontractor needs, so essentially you're asking them to give an undertaking that anyone providing the service does have the right to work in the UK lawfully. That's exactly the way to do it. Make sure that it's a term of your subcontractor's agreement. Just
a quick summary of what the EU settlement scheme looks like, I guess, graphically described here. So you've got an EU passport. Applications can be made via the app or on their computer. It's fairly straightforward. So the HM Revenue and Customs, and they're open until the 30th of June. If you've been in the country less than 5 years, chances are you'll get pre-settled status, or greater than 5 years, that will, you'll qualify for settled status. There might be occasions when other evidence is required if the residency is greater than the tax records show. So, for example, if you apply and say you've been here 10 years, but the tax records only show that you've been paying tax for, say, 6 years or 3 years, you might need to show some more residency records that confirm you've been here longer. With the volume of traffic that's going through the applications currently, this is taking time. So we are recommending to anybody we speak to who this might affect, they should make their applications as soon as possible, sooner rather than later. Some of the questions that get asked: who's eligible to apply? Pretty much anyone who's not, anyone who is a non-UK citizen. When do I need to be resident in the UK? Well, we've covered that previously. How long do I need to be resident? Again, on the previous slide. If you have a criminal record, well, of course, depends on the criminal record. It doesn't necessarily mean that you won't get status if you have some kind of criminal record, but of course, it's not going to help. What will I get once I have settled or pre-settled status? In other words, do I have a certificate of evidence of that? And what if I don't apply before the deadline? From what I've heard from people who have applied, they don't actually get a certificate of status. as such. They do get confirmation by email, but that's pretty much it. And if they don't apply before the deadline, then obviously they fall foul of the rules and are no longer able to work in the UK.
My understanding is that the Home Office will issue a letter to confirm what the status is. It may be that they are now doing that electronically, and that could be to do with new COVID restrictions if there's something along those lines. But my understanding was that everyone will get an acknowledgement from the Home Office to confirm what their status is.
Now, there are, we said before that it's not for you as an employer to interpret the rules or the regulations. We've just added some help here, that EU Settled Resolution Centre phone number for your staff to go and call. They can be assisted digitally. There's all sorts of different areas to help, but this just helps direct people if they're not sure where to go. There's an employer toolkit, just show you there the sorts of things that you can get. It's an intro pack, settlement scheme, briefing information, range of leaflets, posters, fact sheets, digital and social media assets as well. And it shows you how you can use them and where to use them. So UK nationals currently in the EU, there's no change to their rights and status as UK nationals, and UK nationals are covered by the withdrawal agreement. And in a similar way that EU nationals have to apply for settled status in the UK, they'll have to do something similar in the country where they're residing and working. So again, by the 30th of June 2021, we did mention this earlier. So working in the EU, UK citizens. So the UK no longer operate under the European Economic Area regulations for cross-border trading services. So when they're no longer covered by the rights and protections provided by EU directives and the EU treaty rights of freedom of movement and freedom of establishment. So they are subject to other requirements, and that might mean work permits, it might mean applying for settled status, etc. And UK businesses and professionals are regarded as originating from a third country. We are now a third country to the EU, and it's just a term used to indicate that we're not part of that economic area. And UK firms and service providers may face additional legal, regulatory and administrative barriers as a result. So, for example, where you're sending teams of workers into the EU to carry out specific contracts, you may have to obtain work permits for those staff and for those work teams, depending on what they're doing, how long they're doing it for, and what they're earning. Again, that does tend to be territory specific. Every EU country have their own separate rules on that now. So you'll need to check and make sure with the country that you're working in or sending teams to. Service industries, as I said there, need to seek specific guidance on how they need to operate if they're, sending workers out into the EU. And we're seeing also that UK professional qualifications are not automatically being recognised now in the EU. And there is guidance on the website, government website here. However, what we are seeing is there's continued discussions going on, for example, in the legal profession, around the qualifications and whether or not there can be some kind of agreement, and that's still under discussion at the moment. Same for accountancy and other professional bodies that are going through this at the moment. So we mentioned earlier business, pleasure and travel. Restrictions on movement in the EU, you're restricted to 90 days in any 180-day period. You can carry out permitted business activity. And again, that's territory specific, but it will be the sort of thing, for example, as a business consultant, I'm able to go into Europe for a couple of days and consult with a business, work for a couple of days, consulting on their issues and problems in their business, if I so wish. I can go to conferences in Europe. But what I couldn't do is go and work for 6 months and fit into the 90-day period. It's permitted business activity, but what permitted means might be different in different territories. You may need a work permit, visa or residence permit. And again, that's territory specific. I know that's not very helpful, but you will need to check. And we just thought we'd throw this little diagram. It's a heat map of countries that are restrictive about providing work permits. The darker the colour, the less restrictive they are. It shows you that every country has a different view, even within the EU